All right, we're going to start because we don't want to get behind in our time. And I'm just going to welcome everyone, and my friend Jeff Rosen is going to welcome you as well, and then we'll get right to the business of the day. So my name's Jeremy Fogel. I am the director of the Berkeley Judicial Institute, which is located here at the law school. And I've been here for a little bit less than a year, and before that I was the director of the Federal Judicial Center and a proud member of the bench of the Northern District of California. This program is something actually that Jeff Rosen and I have been thinking about and dreaming about for a long time. We worked together on a number of projects, and we thought that the discussion of judicial independence and the role of the judiciary in our society was missing a piece. That a lot of focus on structure and on the constitutional division of powers and the role of judges under that. But what's been missing in the conversation is, who are judges? What do they do? What is the human side of judging? What is the human life of judging? And what we're trying to do this evening is begin that conversation and shed some light on it. I'll introduce the panelists. Jeff will introduce our co-moderator. So here on the stage we have Judge Charles Breyer from the Northern District of California, and been a judge on that bench since 1998. And to his left is Justice Eva Guzman from the Supreme Court of Texas, and she's been on that bench for 9 years, correct? Yes. And is a very well-regarded and successful member of that court. In the second panel, we'll hear from the two individuals who are sitting down in front right now. Retired Justice Carlos Moreno of the California Supreme Court, and retired Judge Danelle Taha, former Chief Judge of the 10th Circuit Court of Appeals, lives in Lawrence, Kansas, and I'll be joining that panel as well. But to get right to the business, this is my friend Jeffrey Rosen, the CEO of the National Constitution Center, and he'll say a little bit more about the program.
Thank you so much, Judge Fogel. Welcome, ladies and gentlemen, to the National Constitution Center on the road. I say that because the National Constitution Center is the only institution in America that was created by the U.S. Congress to educate Americans about the Constitution on a nonpartisan basis. And part of our mission is to hold programs like the one we're honored to hold with Judge Fogel and the Berkeley Judicial Center today, bringing together judges of different perspectives to educate people about the Constitution. I must put in a plug for the National Constitution Center's Interactive Constitution, which brings together the top liberal and conservative scholars in America to write about every clause of the Constitution, describing areas of agreement and disagreement. And this remarkable tool is a model for the kind of dialogue that we're having on the road. We're here at Berkeley last year for our We the People podcast and around the country. This mission of bringing together citizens and judges and scholars and students from 8 to 80 of different perspectives for constitutional education and debate is a meaningful one, and by participating today, I'm so thrilled that you are part of it. This is a remarkable group of judges, and it is a special pleasure and honor for all of us that the first panel will be moderated by the great Michael Lewis. Michael is an old friend. We go back way back in journalism days, and he, as you know, is America's leading narrative storyteller. There's no one who is better able to reveal the human stories behind the most complicated and meaningful financial, political, and judicial dramas of our time. He's recently the host of the best-selling Umpire podcast, where he met Judge Fogel, where he's been interviewing Judge Fogel and other judges about what it means to be a judge. And I know you as well, cannot wait to hear him, the master moderator, reveal the human side of judging with two of America's leading current judges. Please welcome our panel and Michael Lewis.
Thank you. Can you hear us? Is this good? All right. So I'm utterly unqualified to be here. I mean, I am here because of that. I met Jeremy through this podcast, and the podcast was about umpires and referees in various walks of American life. And one of the episodes was about judges and just examining the various forces that were coming in on them that might undermine their authority and make their lives difficult. Otherwise, I know very little about the law except to run from it. So I'd like to start by just. I'd love you each to introduce yourselves and what you do, where you are, to the audience. And
Go ahead. Yeah.
All right. The federal judge is making me go first, so I'll go first. So you heard I'm Eva Guzman. I have the great privilege and pleasure of serving on the Supreme Court of Texas. It is the highest civil court in Texas. I've been on the court since 2009. I served on an intermediate appellate court before that for about a decade, and initially entered the judiciary as a trial court judge appointed by then Governor Bush. My journey has been marked by first Latina on the trial court in Harris County, first Latina on the intermediate appellate court, and first Latina elected to statewide office in Texas. And it's a job I enjoy. And
you received more votes than anyone has in the history of Texas.
well, since you brought it up, Texas elects its judges. That's riddled with all sorts of cons and a few pros. But the last election, 2016, I did become the highest vote getter in the history of the state of Texas for any office, anytime.
Who voted for you, Chuck?
Yeah. Fortunately, we didn't have an election, which I actually thank my lucky stars when the first case that I had was a case involving a fellow by the name of Ed Rosenthal, who had what's called the Oakland Cannabis Club. And it was a case that ultimately went to the United States Supreme Court, where they prosecuted people who had manufactured and distributed marijuana. It turned out that Rosenthal had been authorized by the city of Oakland to be the official grower of marijuana. Okay, fine. The feds decided that he ought to be prosecuted because of this thing called the Supremacy Clause, and he was prosecuted in my court. It was the first case that I had as a trial judge. And believe me, I thanked my lucky stars that I wasn't up for election. It turned out that he was convicted, ultimately, and I sentenced him what I thought was appropriately, which was 1 day in jail, credit for time served. And that was that case. But it highlighted for me, and it'd be a fascinating discussion about what does the independence of the judiciary do to the individual judge who doesn't have to be concerned about being popular? The fact that you got the most votes actually is the best thing I've heard about the elections process. But I would be concerned, and there are a lot of examples that we can give, even in California, about judges who render unpopular decisions and then are voted out not because that judge didn't do his or her job, but because that judge rendered an unpopular decision. And since I thought we were talking about stress, that'll give you stress. I'll tell you that.
So I want to do with you, both of you, what I did with Jeremy when I first sat down with him, because it's not obvious how a person becomes a judge. The social role is so powerful. Once you're the judge, that's all you are. But once upon a time, you were little kids with other ambitions in life. And so could you just start by explaining how? And Ava, you start here. Just how you become a judge. How this happens, and is there anything in your past that sort of led up to it where you said, yeah, this all made sense? It made an awful lot of sense that I ended up here.
Well, and everybody has a different path and a different journey, but in the end, I think they do, and people come, so there are people sitting in the audience right now that are law students that know they're wanting to be a judge, and that's their goal. That really wasn't my goal. I didn't see myself in the judiciary, but it was a little serendipity, a lot of hard work, and in the end, it's public service. So I'd been doing, as a young lawyer, I served on a grievance committee, I did a lot of community work, and there were a lot of ways where I engaged with the community. A judge passed away, and I had 4 or 5 people come to me and say, you ought to apply for this job. It's political in Texas. I was apolitical. And they already had 30 applicants for this particular vacancy, so I thought, well, why not just go ahead and do it, because the odds are really against you. But I did.
Is it going to reject you?
Yes. No, do it because it was an opportunity.
Right.
And you have to take those risks. And so I did. And so I think any lawyer is sitting in a courtroom and you're watching the judge, and I could do that job so much better.
But actually, in this room,
That's what they say in my court all the time.
but I want you to actually back up just a little more before we jump forward into what you're doing on the bench. I grew up in a house. My father was a lawyer and told me to run as fast as possible away from the profession. He was a lawyer who wished he was something else. How did you get interested in the law?
That's a great question. Yesterday I was. I'm from a very working class background, but yesterday I was in the airport, and it was late, and I walk in the ladies' room, and I see the custodian, and she's on her knees, cleaning, and I'm thinking about coming up here to be interviewed by the Michael Lewis.
There are lots of them.
And I thought about my mother. I'm one generation away from that life. And she was a custodian at the University of Houston, where all her kids went to college. And so that just kind of came back to me. So that's my background. So when I thought about the law, why do I want to be a lawyer? For me, it was to make a difference. It was to really go back and engage with people that grew up like I did, who are invisible. And I would see them as a lawyer in ways that other people wouldn't.
So it was justice, social justice that interested you.
It was making a difference.
Chuck, how did you get into this?
That's a tough story to follow.
No, it's...
because I wanted to be an actor, and I failed at that.
Did you?
Well, it was during Vietnam, and you had to. I succeeded in college in that, and then I wanted to go out and see whether I could actually make it as an actor. And the problem was that you'd be drafted. So my father, who was conservative in that regard, said, you better go to law school. So I ended up here. And at the end of the first year, I was really unhappy at law school. I didn't like it, didn't like what they did. I didn't find it particularly interesting. And I said, I'm quitting. That's it. I'm just quitting, and I'll figure out what I'm going to do. And he said, well, before you do that, why don't you work as a law clerk to a personal injury lawyer, a lawyer by the name of Marvin Lewis in San Francisco, and just follow him around. Well, that's what I did. And I went to depositions, and I went to trials, and I thought, my goodness, this is fabulous. You write the play, you act in the play, you direct the play, you produce the play, and there's generally some kind of audience. That's actually what I got as a judge. I got my audience. But indeed, I have to tell you what I would say to people. I mean, and I think really to answer your question, what does it take to be a judge? It takes luck. Among other things, and it should never be downplayed. I mean, federal judges always say, what does it take to be a judge? You have to know a United States senator. That's what it takes to be a judge. But I think actually it takes luck, among other things. So how did luck play with me? And I will tell you, that that I think that because I had so many different experiences, I was a prosecutor, I was a Watergate prosecutor, I was a defense lawyer for 25 years. I did all sorts of different things. And those experiences that I had, I actually think I was able to bring to being a judge. So I tell law students, look, you'll have a lot of opportunities. Take the path not traveled, or take the difficult path, because it will make you a different person. And if what you want to be is a judge, it's great to have different experiences. It's great to have your experiences. It's great to be able to relate to people, and especially as a trial court judge. And the only way you're going to relate to people is to have had different experiences. And that's what I think qualifies a person to be a judge.
What year did each of you become judges? When did you?
So when we first became judges?
Yeah.
Gosh, a long time ago, 1999.
Huh, that's great. 98.
So
I'm
there you
even
go.
older.
So have the pressures on you changed since? Has the environment in which you're judging changed noticeably to you in the last 20 years?
I'd say absolutely.
How so?
I think, and I guess my greatest concern is that the judiciary become polarized. It's very, very dangerous that the courts start to take positions that appear to be partisan positions. That will be more destructive of the judiciary and the rule of law than anything that I can see. So I am alarmed by it. I have some of my colleagues here. I know my colleagues. My colleagues will not do that. My colleagues will try to call them as they see them. Call the balls and strikes. That's what we do.
Actually, what I meant was more when you walk into the job and you sit in the chair. Are there different pressures on you now than there were 20 years ago? Do you feel watched in different ways? Do you feel scrutinized? Do you feel criticized? Are you worried about different things?
Well, I think the dialogue has changed and the conversations have changed. I mean, I became an appellate judge in about 2001. I wrote an opinion, maybe the newspaper picked it up in Houston, and that was it. You know, maybe they rarely praise occasionally, but, you know, if they want to criticize it, it's there. Now I wake up and I go to Twitter, because that's the first thing I do in the morning, and there it is. And so as the judge, so that brings stress. So I'm being criticized, in Kentucky or wherever.
So we just stop here for a minute. You tweet.
Yes, at Justice Guzman, just in case you tweet.
Do you tweet?
No, I
So is this the
have
difference
no
between us?
social media, and I have no social media skills. I have.
How do you know if you haven't done it? You might be a.
Because I wouldn't even know how to do it.
Right.
I mean, I have to phone. I have to phone my son to connect the telephone or something. I mean, it's terrible what I am. I'm a sort of this antediluvian skills, and so I can't really do anything. But I will tell you that I do tell that judges are really discouraged from engaging in social media. Interestingly, I just was away for 4 weeks, just traveling, having a great time bicycling and so forth. And we decided as a group not to read the paper, not to watch TV. And I felt better because there's nothing you can do about it.
Right.
You see, and it's a good idea to detach yourself from all of this.
But there's also an argument for not being too detached. I mean, let me just stop you. So you said judges are they're asked, it's frowned upon.
Yes.
But you do it. But it's a different situation because you're an elected official. You have to. It would be political malpractice for you not to engage with your audience. But is it? What's the argument for?
I think it gives the public an insight into the judiciary. When you think about the public's confidence in the judiciary, it may be at an all-time low. It certainly is among minority communities. Civics, as you know, civic education, people just don't know. They don't know who's on the Supreme Court, how many judges are in a court, what judges do. Their idea of judging is Judge Judy. I mean, that sort of thing. And so when you're on Twitter, when you're accessible, the public gets an insight that they wouldn't otherwise have. They see the process. They see you. They hear your voice. And at the Supreme Court, all of our oral arguments are on the web. You can tune in live. You can watch it later. It's scary when you're the judge. And there's a T-shirt that I think says, "If my mouth doesn't say it, my face will," and that's sort of me on the video on the court. So I really work on that stoic face. But that again, it's the public having an opportunity to see their courts at work and to understand a little bit more about what kind of questions do we ask. We've had issues come up involving religious issues or gay marriage, and the public gets a chance to see what kind of questions the judges are asking.
How do you feel about that, Chuck?
Well, I am in favor, actually, of cameras in the courtroom. In particular types of cases, very controversial, but I was very disappointed that the Prop 8 case wasn't broadcast. That would have been the greatest learning experience that the American public could have had about gay marriage and myths that surrounded it and process to develop what is the evidence of this idea and that idea. And regrettably, it wasn't broadcast. I think, like our Supreme Court, like your Supreme Court, they do broadcast the arguments. The Ninth Circuit broadcasts arguments. I think it's a good idea. There are concerns, privacy concerns or concerns about protecting witnesses and so forth, but you address it on a case-by-case basis.
Right.
You just don't have an ironclad rule.
You're just saying that public approval of the judiciary is at an all-time low, and that's how is that affecting your lives? I mean, are you on the receiving end of hostility, criticism, pressures that maybe you wouldn't have been?
That's just part of the job. And the public has the right to voice disagreement. In fact, we should listen to voices that are different from our own voices. I wish that as a society we engaged in more conversations with people who don't think like us, with people with different ideas. But one thing that came from this idea that the public doesn't have a lot of confidence in the judiciary was a summit that I put together in Texas. And it's a summit that the theme was the implicit bias in the justice system. So I invited Professor Raklinsky from Cornell to come down. I had about 400 or 500, the court did, I led it, but it was a Supreme Court initiative. We had about 400 or 500 stakeholders, prosecutors, defense attorneys, judges. That was right after the 7 police officers had been killed in Dallas. We had the wife of one of those police officers there. We also had some of the folks that had experienced the police brutality, a man who'd spent 20 years in prison, wrongfully convicted. The system had failed him. So that's how the judiciary can respond to concerns about confidence in the justice system. So that was one thing I did that I'm very proud of in Texas.
It's interesting that we've moved. We're clearly out of an earlier era where the judge could sit behind the robes and hide, and nobody paid too much attention to who he was as a person. And that, you can't do that anymore. You can't hide anymore. And you can't hide specifically, but generally. And this is one of the things we kind of explored in the podcast was everybody's aware of human error. Everybody's aware that human beings that there's cognitive bias. Have you had to adapt to the growing awareness of your own fallibility? I mean, have you had training, for example, in cognitive bias? No. Have you?
Well,
what has been the response to defend yourselves?
Jeremy Fogel was a great leader of the Federal Judicial Center, which put an emphasis on making judges aware of such things as implicit bias. And we now have fashioned videos that we show jurors, prospective jurors, and we give them examples of implicit bias so that they're aware of it. We have fashioned instructions that I give, and my colleagues give, both before jury selection, after a jury has been selected, but before the evidence, and finally at the conclusion of the case, so that people are aware. You know, the irony of implicit bias is you guys say, do you believe in implicit bias? Of course not. Of course I don't. I'm not biased. Just ask me. And the problem is it's implicit, and you have to make people aware of these problems. And I think that that's something that now the courts are very aware of, and I think jurors want to be honest.
What kind of training does one get to be a judge? I mean, when you get the job, what do people do to make you? How do you learn how to do it? What's required of you in the way of? Are you get given the robe and you just climb into the chair and start doing it?
You're the baby judges school. So
right.
most judges go, to a week. You go away for a week and you do that. I went back to try to be a better appellate judge. I went to Duke Law School. They have a judicial LLM. I spent 2.5 years in that program. But I think judges have to work at it. And part of that, every state has mandatory training, mandatory continuing education that you do. If you're a smart judge, you recognize what you don't know, and you ask the right people. You do the research. You continually work to improve yourself, and one way to do that is to ask a lot of questions.
Are you ever presented? Do you have feedback the way NBA referees have now, where you get your errors played back to you so you can see the mistakes you made, and so you can improve?
That's called
It's
the
called
circuit.
the appellate court. That's what I do.
All right. Well, so how does that? So you do get to see your mistakes.
Well, you get to see. There's a tendency to bury some of these mistakes. I mean, I think there are a lot of types of feedback and a lot of types of instruction. Of course, you have baby judges school and so forth. But one of the great resources that you have are other judges, are the colleagues of your court. And if you are lucky enough to be in a collegial court, and we are, where we will have lunch frequently 4 or 5 times a week together, where we discuss problems, where you can walk down a hall and go into another judge's chambers and say, what am I going to do? What do you think about this? What do you think about that? It's that constant feedback from other people that give you an insight and change your behavior. It actually changes your behavior. So I think that that's extraordinarily valuable. But it is only as valuable as having a bench that's diverse, that will make you aware of different problems, because it is the fact. My life, I wasn't aware of all the. I mean, it's a great contrast, because I wasn't sensitive to all these things. I just had my 60th high school reunion, and just before I went to it, I read Rosa Parks's story of how she was arrested in Birmingham. She was arrested when I was a freshman at high school in San Francisco, and I guarantee you nobody in San Francisco was aware of that I was aware of that injustice. So you've got to have a diverse bench. You've got to have people who've had different experiences, because that's how you learn. That changes your behavior.
This is getting back to the original question, but has anybody ever pointed out to you a mistake you've made where you went, oh my God, that was a mistake?
Yes, here.
All right.
I sentenced somebody, and I'll tell you a bit why. It may be interesting. I don't know whether it is or not.
It's already
but
interesting.
I sentenced somebody to whatever it was. It was a lengthy sentence. As soon as it came out of my mouth, I knew it was a mistake. And I walked off the bench, and I got to the door, and I turned to my courtroom deputy, and I said, bring them back tomorrow. I want to change the sentence. It's just terrible. Well, the law is, every now and then you have to look at the law. The law is that you can't change it after you've
Is that
And
right?
After you've left the court,
You're not allowed to change your mind.
you cannot change it. It's called sentencing remorse. You just can't do it. But I did it anyway. Seated in my court, yeah, this is terrible, but seated in my courtroom was the United States Attorney at that time, a fellow named Bob Mueller. They have heard of him. So he's sitting there, and I'm changing this sentence, right? Yeah, I just changed it. I said, well, I meant to say 38 months, not 48 months, or whatever it was, and I walked off the bench. About a week later, I saw him in the elevator. And he said, oh, that was very interesting. He said, it's very interesting. He said, there's some question as to whether or not you had jurisdiction to do that. I said, I can understand that reasonable minds might differ on that issue. He said, well, you know what? We're not going to appeal you because we think you came out with the right answer. So, yeah, that's called sentencing remorse. Yeah. I made that mistake, and Bob Mueller has been correcting my mistakes for years.
So, Ava, have you ever had a moment where you realized that something you'd done you wished you hadn't done?
You know, I think as a trial judge, there may be those moments that may come more frequently. On the appellate court, it's a little different. You know, we don't decide these cases in a vacuum. You have, the briefs, the oral arguments, the lawyers come and present their cases. You have your colleagues that weigh in. Then you have these law clerks right out of law school with great ideas about what the law is or ought to be. And so you don't decide them in a vacuum. You talk, you have these conversations, and you have an opportunity, you can issue an opinion. I've had very few. They can file what's known as a motion for rehearing, and we don't have remorse about these things. You can actually change, and the court has in the past, and I have in the past actually changed my mind on rehearing. It doesn't happen that often, but you realize you made a mistake. Judges are not infallible. There are times when you just got it wrong, and that's when you'll see those rehearings granted.
By the way, we're going to open this up to the audience for questions for just a little bit. We only have about 10 minutes left, but if you've got something you would like to ask them, there are microphones on both sides of the room, and we'll start to take those questions. You were sitting down with someone who wanted to be a judge, and you were to evaluate whether they were actually suited for this. What would you look for in a person? What makes someone good at it?
In my view, a commitment to public service. A commitment to fairness and to impartiality. There's a certain skill set. Ideally, if you're going to be a trial judge, you want someone who's actually been in the courtroom. And to tell you that, I was thinking about this story because it was so different in the early 90s. My first jury trial by myself, I was so nervous, and it was in a small rural county in Texas, and the judge says to the opposing counsel, Mr. So-and-so, I'm going to take Ms. Guzman back, and we're going to pray. I'm going to open the Bible, and we're going to read some scripture before closing arguments. Now, you can join us, or you can stay right here. So the judge and I went back, and we prayed, and I won the jury trial. But that's how different it was in the beginning, and you couldn't do that now, and you wouldn't want to do that now, but you could back then.
I would say a couple of things that are important. In addition to having the Lord on your side. And I don't know too much about that, to be truthful. But I think that you have to have the ability and a willingness to make decisions. Now, I'm talking about basically a trial judge. If you don't like making decisions, if you're one of these people who said, well, on the one hand, there's this, and on the other hand, there's that, and I don't know, and so forth. Look, we're paid to make decisions. I mean, paid, not paid, but we're there to make decisions. That's number one. Number two is don't have an agenda. Just listen to the evidence. I can't tell you how many times my mind has changed after listening to the evidence. It's just great. And why I love my job, and I do love it, it's because it's exciting, because it's filled with unknowns, because it's intellectually interesting, because it can make a difference in people's lives. It really can. So all of that fits as long as you have the temperament, one, to make decisions, and two, don't become so invested in your opinion that you're not going to listen to whatever the evidence is.
Why don't we have someone here?
Hi, is this working?
Yeah.
Yeah, I'm Judge Ron Greenberg, Alameda Superior Court, retired. The name of the program is The Human Side of Judging. What is it, I'd ask each of you, to be a humane judge?
What is it? I'm sorry, you didn't hear.
What is it to be a humane
Yeah, how do
judge?
you define, being a humane judge?
Well, it is to understand whatever you do has consequences, real human consequences, and to appreciate those consequences. It doesn't mean you're guided by those consequences, but it means that you understand it. Every case I've had, a defendant's family, by and large, has been severely impacted by the sentence that I impose. And they are innocent, frequently just another set of victims. So it's important to understand that. You can ask why. I think because it rounds out your sentencing. The hardest thing that I have to do, and every trial judge has to do, is sentencing. And the reason sentencing is so hard is because there is no right answer. There may be a right answer to whether alfalfa is a genetically modified, whether it ought to be accepted or not, but there's no right answer to what the right sentence is. And I've done sentencing now various ways over 50 years, and I could not tell you what the right sentence is. I can tell you about a lot of wrong sentences. I can't tell you about the right sentence. And the problem is for judges, that's the one thing that they don't have the certainty on, which is sentencing. So what is humane? I don't know. We all have this task, that is judges, of trying to balance all of the considerations and not to forget that it has implications for the public.
Ava?
And I think judges, we're human beings. You put on a black robe, as Justice Thomas says, that doesn't mean you stop being a human being, but being a humane judge means you can identify. You can have a conversation with yourself, identify your biases, put those aside. Look at the case before you, look at the guiding precedents, look at the statute's language, and really, really, as the judge said, consider the decision in a way that's faithful to your oath, but that also understands that the consequences and that there's a real family or a real case in front of you.
Thank you.
Do we have somebody else? All right, here we go.
In California, we have a commission on judicial performance where members of the public and attorneys can file reports on judges who may be impaired or may be committing on a regular basis judicial misconduct. A state auditor's office just concluded an audit of the Commission on Judicial Performance and concluded publicly that it was an institutional failure. Complaints were not followed up on. There was no cross-referencing of a complaint from one person against a judge with another. And essentially, it was an institutional failure. And that became public through the newspapers, but I doubt many lawyers or the public even know about this. From my perspective, as a trial lawyer over 40 years, I can give you one example of how this judicial collegiate feeling is a failure. So I had a trial judge who came back from lunch totally drunk. I knew he was drunk. My clients knew that he was drunk. I called a judge in the same court, and I said, I have a problem. He's coming back from lunch drunk. And that judge told me, look, we all know this. He's going to retire soon. Don't do anything. Just back off.
Well,
and so there is a flip side.
Because the Ninth Circuit had this problem the Ninth Circuit and the United States, I mean, the federal judiciary, recently there was an incident in which the former chief judge, basically resigned, Judge Kaczynski. Okay, so it was a problem of harassment. And as a result, the Chief Justice and the Ninth Circuit judge appointed committees to address the problem. We set up a whole set of standards, which are part of the Code of Conduct, dealing with judges' requirements to not to harass, not to bully, not to do these sorts of things, to have training for it, and to make it a requirement that if a fellow judge, a colleague, sees this type of conduct, that judge has a duty to report it. And failing that, that judge has potentially violated the Code of Conduct. So I think you've identified a real problem. The federal judiciary, I know, is trying to deal with it. I assume states all over the United States are addressing it too.
Yeah, judges aren't immune to some of the same problems that plague lawyers: alcoholism, mental health issues, secondary trauma, particularly judges in criminal courts or in the foster care system. They're not immune from that. We have a Commission on Judicial Conduct, and it's effective. It's just went through sunset and came out pretty well. But I think when you observe something, that each state has a process and an avenue, and sometimes you have to keep pushing. There are times when you raise something and nothing's done, and you just have to keep pushing, because in the end, you know that a justice system that's serving the public well requires that you're the one that keep pushing, because that judge is coming to work drunk. I mean,
We only have a couple of minutes, but I'd love for you both to give me a sense of what the biggest misconceptions of your job is that you encounter. And you probably, especially since you're on Twitter every day, you probably are the world's authority. But
so, the conversations that take place sometimes, in our communities, on Twitter, and in the media, there aren't always black and white answers, particularly when you're looking at very complex legal issues, when you are considering the rights of both sides and that sort of thing. And I think the public expects an answer, and this is absolutely right, or this is wrong. And the conversations are much more nuanced than that. And the process to arriving at a decision, judges don't come to work that day and, I think I'm going to do this today because that's what I feel I should do. And I've been in the judiciary a long time, but that's something the public thinks that we do, that we come in and our mind is made up one way or another. And maybe that happens, and maybe it does. No profession is perfect. But by and large, the majority of judges come in and they really want to get to the right answer, and the public doesn't always see it that way.
And I think the one of the great problems is that what's not factored into public acceptance of a judge's decision is the fact that the judge took an oath to follow the law, and the law dictates a particular result. And the result may seem unjust. It may seem out of touch with reality. It may seem to be the wrong result in a particular case. But if the law dictates it, a judge has a sworn duty to follow it. And I think that is generally not recognized by the public when a story is reported. The result is always reported. Judge does this, judge overturns this, judge affirms that. But the reason, frequently, that the judge did all those different things was because, at least in the judge's mind, the judge required it. The law required it, rather. And so I think that's sort of a misconception.
all right, this courtroom is adjourned.
Great.
So, thank you.